Good day. I am Attorney Maria Luisa Villarin of the Humanitarian Legal Assistance Foundation, and I am to discuss the Philippine criminal justice system. Protecting and advocating the rights of persons deprived of liberty, or PDLs, necessarily entails a deeper understanding of the criminal justice system. Primarily, the problem we want to address is overcrowding in jails, especially for PDLs who are still undergoing trial. As of October 2021, the Bureau of Jail Management and Penology jails had a congestion rate of 408%, with BJMP jails housing more than four times their actual capacity. Not only is personal space scarce, but the budget is also limited. In the 2020 General Appropriations Act, the daily budget for meals per PDL amounts to only 70 pesos. That covers all three meals in a day. Healthy and nutritious meals is something they definitely cannot afford. As for the daily medicine allowance, each PDL is allotted 15 pesos. With the lack of nutritious meals and the congested jail's tendency to create an environment susceptible to developing diseases, and not even taking into consideration newly committed PDLs with existing illnesses, the medicine allowance is definitely not enough to ensure against sickness and other health issues. One can think that the problem can be solved by increasing the budget and building more jails to accommodate the current number of PDLs. But this is just a short term solution. When more jails are built to accommodate the current number, by the time those jails are finished, the population as well as the number of PDLs would have surely grown as well, and the problem would not have been solved. The change we need is a change in strategy. International standards are encouraging the shift from a retributive justice approach to a restorative justice approach. Numerous studies support that imprisonment does not really help with rehabilitation. Thus, using alternatives to imprisonment, especially for those still undergoing trial, is highly encouraged. A closer look at the five pillars of the criminal justice system can show us areas of opportunity to avoid detention. The pillars are law enforcement, prosecution, the courts, the corrections, and the community. We, as students of the law and future key persons in the criminal justice system, can make use of these observations and learnings to promote the shift away from imprisonment and to help in any way we can to protect PDL rights. The first pillar is the law enforcement pillar. This involves all law enforcement agencies, the police, the NBI, PIDEA, and even barangay tanods. Their duties include maintaining peace and order, investigating crimes, conducting search and seizures, making arrests, executing entrapment operations, and to some extent, safekeeping the accused. The rule in criminal procedure is that an arresting officer needs a validly issued warrant before making an arrest. And there are only three exceptions to this rule: getting caught in the act, hot pursuit, and being an escapee. Curiously, most PDLs still undergoing trial were arrested without a warrant as a result of buy-bust operations. In fact, from my experience from jail visits, only 1 out of 30 PDLs are arrested with a valid warrant. Odd, isn't it? The exception to the general rule seems to have become the norm. Undeniably, making use of a legally sound buy-bust operation as a valid means to conduct a warrantless arrest is more efficient compared to the tedious process of building evidence to prove probable cause and requesting a warrant of arrest or a search warrant from a judge. This necessarily helps in increasing the number of arrests made by law enforcement. However, there is a real cause for concern when the use of buy-bust operations is abused and planting evidence is done by some law enforcement officers in order to achieve a quota to suggest excellent performance. When a quota is reached, it may seem like law enforcement officers are doing their jobs. But then, is making arrests the essence of their jobs? No. Their primary duty is to maintain peace and order by conducting investigations. Making arrests and conducting searches and seizures are only incidents of their primary duty. There is a need to shift the focus from the number of arrests made to the number of crimes solved. With this shift, not only will there be a decrease in baseless arrests, but there will also be an increase in the attendance of arresting officers in court hearings and will consequently result in fewer postponements and a speedier end to criminal trials. The second pillar is the prosecution pillar. This pillar includes the duties of prosecutors to investigate and or cause to investigate all charges brought before them, to conduct preliminary investigations and inquest procedures, and to prosecute criminal offenses. Also, as counterparts of prosecutors, defenders also form part of this pillar. Foremost is the long-standing issue of the shortage of prosecutors and public attorneys and the mountain of work they have. As law students, I hope you consider taking the path of a prosecutor or public attorney. Both roles are crucial in the protection of the rights of the accused. Public attorneys represent and defend those who are indigent and cannot find independent representation, while prosecutors ensure that charges against them have enough evidence to establish probable cause. This way, no frivolous suits are filed and no one is detained without sufficient grounds. In warrantless arrests, inquest proceedings are crucial because this is where inquest prosecutors determine the validity of warrantless arrests based on all available evidence from law enforcement officers and a proper interview with the accused. If the arrest is found to be illegal, immediate release is ordered and groundless detention is avoided. Unfortunately, it is common to hear that there are some inquest prosecutors who, after reviewing police reports and available evidence, no longer interview the accused and just choose to push through with the filing of the case, leaving the decision on whether an arrest was legal or not to the judge. Although this is within their power to do, it just seems like a wasted opportunity to avoid adding to the already clogged court dockets. Another aspect that can be improved on is the performance indicators for both prosecutors and public attorneys. Both their offices base incentives on the quantity of cases won rather than their contributions in seeking the truth to each of the cases they handle. A change in the performance indicators may motivate prosecutors to be firmer in screening cases that have to go to trial and, as a result, also reduce the workload for themselves, the courts, and the public attorneys. The third pillar is the courts. Their duties include the issuance of arrest warrants, search warrants, commitment orders, and mitimos, grant of bail, furlough, and release of recognizance, hear and adjudicate cases, impose penalties, and grant probation. One of the major causes of overcrowding in jails is the slow disposition of criminal cases. In the Judicial Annual Report of 2019, lower courts were reported to have had 654,604 pending cases. It is not uncommon for lower court judges, even those newly appointed, to have around 1,000 pending cases in their dockets. Trials should ideally take not more than 2 years to finish, but the reality is far from that. As of June 30, 2019, the Supreme Court reported that for cases filed after the rules on continuous trial became effective in 2017, 64.3% of the cases were resolved within 100 days. But for cases filed before the rules on continuous trial became effective, only 2.7% were resolved within 100 days. Aside from the heavily clogged court dockets, another issue is the added requirement of undergoing a drug dependency exam or DDE as a condition for release in the OCA circular on plea bargaining. In the revised penal code, it is required that a PDL who has served his sentence shall be immediately released. In the same way, the Dangerous Drugs Act does not require a DDE before the release of a PDL who has served his sentence. Unfortunately, in some provinces, doctors accredited by the Department of Health to conduct DDEs are very limited. In fact, there are regions with less than a handful of accredited doctors but with thousands of PDLs who are required to undergo a DDE. Necessarily, this results in thousands of PDLs who have fully served their sentences that still cannot be released because they have to wait for who knows how long to undergo a DDE. Although this issue is not within the court's full control, being entrusted with the supervision of PDLs, the court should be open to find alternatives that protect the rights of PDLs and are still within legal bounds. An example would be the practice of one court that allowed the release of PDLs who have fully served their sentences and mandated them to undergo the DDE after their release. The fourth pillar is the corrections pillar. It primarily involves the safekeep of the accused, which includes escorting them to and from wherever ordered by the courts, guiding them for their treatment and rehabilitation, whether institutional or community-based, and granting them time allowances and parole. The correction system in the Philippines is a fragmented one, which is why in this pillar, the struggle is in ensuring that the rights of all PDLs are equally protected. There are several types of jails being supervised under different government agencies. Under the Department of Justice, there is the Bureau of Corrections, the NBI lockups, and the jails under the Bureau of Immigration. Under the DILG, there is the BJMP jails and Bahay Pag-asas. Under the DSWD, there is the Regional Rehabilitation Center for the Youth, and there are jails in the PDEA and the Department of National Defense. With a fragmented correction system, the implementation of a uniform standard for the treatment of prisoners as required in international law is far from being achieved. For example, there are provincial jails that are well funded, while other provincial jails are underfunded. Jails from the BJMP are provided with more trainings and resources compared to some provincial jails. Standards for hiring are different among the different government agencies. In this situation, even if more laws supporting rehabilitation and reintegration are enacted, if the fragmentation is not addressed, equitable implementation will not be possible. Finally, the last pillar is the community pillar. This is the most important pillar because this is where the journey through the criminal justice system begins and ends. It includes crime prevention, dispute resolution, diversion, reintegration, and the opportunity to practice restorative justice. Foremost, crime prevention, when prioritized by a community, immediately reduces the increase in congestion rates. It is not unknown that the common causes of crime are poverty and lack of education. Strengthening community programs on crime prevention not only benefits the PDLs, but also the members of the community because they are made aware of the social causes that lead to crime and are empowered to take part in preventing crime in their own community. Aside from crime prevention, the practice of restorative justice in all types of dispute resolutions is an opportunity only available in this pillar. Restorative justice, put simply, is recognizing and addressing the needs of all persons affected in a strained relationship. When a crime is committed, the persons involved are the victim, the offender, and the community. The victim being the direct receiver of the action, the offender being the doer, and the community being an indirect receiver as well. In practicing restorative justice principles, the needs of all these persons are heard and addressed. Thus, all stakeholders are given the opportunity to heal and move forward. In a litigious setup, such as the current traditional process in our criminal justice system, the victim has no other option but to put blame on the offender and wait for the offender to be convicted in order to achieve retributive justice. The offender, on the other hand, has no other option but to go through the trial and defend himself however possible. If convicted, he shall spend his time in jail by doing all sorts of activities that do not even necessarily address his needs to ensure that he will not commit the same crime again. As for the offender's relationship with the community, no reparation is attained. Once an offender is detained and out of sight, the community tends to forget about them. So, when the time comes that a PDL has finished serving their sentence and is returning to the community, the unaddressed concerns from before will certainly be revived. Consequently, the ex-offender will struggle to be accepted in the community, and this struggle might give rise to a tendency to re-offend. Clearly, the 5 pillars cannot be observed and understood independent of each other. These pillars overlap in more than one ways. Law enforcement and the community pillar overlap in working towards maintaining peace and order and preventing crime. Law enforcement, the prosecution, and the courts work hand in hand in ensuring that criminal trials are disposed of as quickly and efficiently as possible. The corrections and community pillar work compatibly in aiming to rehabilitate and reintegrate ex-offenders and allow them a second chance to live in harmony in the community. The issues previously mentioned were not for the purpose of pointing fingers, but rather, it was meant to steer you to think about how you can help in bringing about change. Truthfully, it can be a little overwhelming to think about. But as students of the law, We have a duty to uphold the rule of law and to protect the rights of the marginalized. We have to trust in the criminal justice system and remain steadfast in the belief that the system we have will change for the better, because the people involved know and understand their duties and responsibilities as key persons in the five pillars. As future members of the bar and future stakeholders in the criminal justice system, I encourage you to equip yourselves not only with the knowledge of the law, but with experiences that help you understand why the law is there and who it intends to protect.